webinar series, Protect Your Bright Idea. Protect Your Bright Idea. I'm glad to have you with me this evening. And before we get into it, I just want to give you a nice warm welcome and say thank you for joining me this evening. The goal of tonight's webinar and even the webinar series is to educate, empower, and embolden women to confidently build and grow their brands. And the objective of tonight's webinar in particular, the Protect Your Bright Idea webinar, is for you to practically learn how to protect your intellectual property while growing your brand to increase your brand's value. We definitely want to help you understand how to grow your brand and protect your brand while growing your brand in order to increase your brand's value. So my name is Curleen Jean-Louis. I am a Massachusetts native, first generation Haitian American, a serial entrepreneur, and the founding attorney of the KGL Law Firm, PLLC, which I launched in 2012, November 2012. I've been practicing law for over 10 years, and I was a former litigator before I began serving businesses, nonprofits, entrepreneurs, creative, and brand owners. I represented in court in criminal matters and civil litigation matters, traditionally underserved groups, immigrants, low-income persons, persons of color, and I transitioned into the brand protection realm in 2018. So I've been serving brands, entrepreneurs, businesses for the last 5 years. I am admitted to practice law in the states of New York and Massachusetts, but I do serve trademark clients in all 50 states as trademark matters are federal matters. And so I serve trademark clients in all 50 states. But that's enough about me. You didn't come to hear about me tonight. Let's get into protecting your bright idea. So tonight, the plan is to do a brief overview of what is intellectual property. If you were with us last time for Trademarks 101, this will sound familiar, but we're going to review for some and introduce for others what is intellectual property. We'll discuss the different types of intellectual property or IP, and we'll also finally wrap up with practical ways that you can protect your brand if you're thinking about launching your brand or you've already started your brand. And when I say brand, I mean creatives, business owners, nonprofit directors or executive directors of nonprofits. I'm talking about all types of businesses. Brands encompass all of that. So this is applicable to everyone. Let's get into it. What is intellectual property? Short answer. Intellectual property refers to the creations of the mind. I took this quote or this definition from the World Intellectual Property Organization, commonly referred to as WIPO. Intellectual property refers to the creation of the mind, whereas real property refers to tangible things that you possess, such as a home if you're a homeowner, or land if you own the land on which your home is built. Intellectual property refers to creations of the mind, things that you owned because you created it, because you thought it, because you brought it to life and used it. So those are things that emanate from the mind, intellectual property. And we're just going to get into the different type of IP or different types of intellectual property. Commonly, there are four. I'm going to give a very broad overview. I'm not a patent attorney, and I'm a trademark attorney, and I do also practice in the area of copyright law, but patent law, just briefly touch on that, and trade secrets as well. So if you are interested in understanding the different types of intellectual property, we're going to get into that. And the reason why I also want to get into the different types of intellectual property is because as a brand owner, you may not know the IP you possess. Knowledge is power, applied knowledge is power. So I just want to touch on the different types of IP so that way you yourself can distinguish or identify the types of IP you may hold. You may think that you only want to file for trademark protection, but you may have also some copyright rights or some patent rights or some trade secret rights. So I want to just give a brief overview so that you can best understand the types of IP that you may hold in your business and or brand. And so we'll get in first with copyrights. Copyrights protect original works of authorship. And the work has to be expressed in a tangible medium, which basically means it has to be, if you have a book idea, you can't protect the idea that's in your brain. You have to write that book out and write that idea out in the form of a book, and the copyright would protect that. If you create a screenplay, If you create a choreographed dance, you can register that work for copyright protection. The fun thing about copyrights is that you immediately have a copyright, like you have a copyright right once you put that creative idea in a physical form. However, it's important to register your copyright with the copyright register in order to protect your rights. Say you come up with a book idea or movie idea and someone infringes on that or copycats that or steals that. Essentially, with a registered copyright, you have more avenues available to protect your idea and get paid for somebody violating your rights versus if you do not choose to register that copyright. As I said, if you have let's go back, I'm not done with copyrights. If you have a website for your brand, the messaging, the information you've taken and put together and created is copyrightable. You'll see here, I have at the bottom of the slides, copyright, copyright 2023, KJL Law Firm PLLC, all rights reserved. So even if you don't register certain works, it's a good practice to include that at the bottom, just so you can put others on notice that you are the copyright holder. And so copyrights focus on the brand's messaging, and it lasts for the life of the author plus 7 years. One great thing about copyrights is that not only do you have a right to the work the original work of authorship that you created, but also derivative works. That's why sometimes people buy the rights to a book, because from that book they can create a movie. From that book they can create a TV series. If you take a look at Netflix, a lot of the movies that are created on there, or some of the movies created on there, have originated from books. I can't remember the one with the film with Zoe Saldana, the series I should say. Is it From Scratch? I think it's From Scratch. That is actually based on a book. So the sisters who own the rights to that book sold those rights to Netflix. That's another fun part of registering your copyrights and protecting your rights. You're able to sell, license, and or transfer those rights, and that can generate some income for you as well. Trademarks. They protect words, phrases, symbols, logos. So think your brand name. If you have a logo for your brand, if you have a tagline for your brand, Nike has a tagline, "Just do it." Those are things that are eligible for trademark protection. And so trademark really focuses on your brand's marketing. Trademarks are your brand. When people think of your brand, what do they think of? That's your trademark. That's the goodwill that you've generated and associated with your brand. And trademarks can last indefinitely, aka forever. So you can pass on the trademarks, and the trademarks can last ad infinitum. So if you protect your brand and you pass on your business or you sell your business, that trademark is able to be protected forever if you continue to use it exclusively and complete the maintenance filings with the USPTO, or the United States Patent and Trademark Office. Patents. There are different types of patents: utility patents, design patents, plant patents. Plant patents, we won't get into them, but if you kind of create a species of plant, a new species of plant, you can apply for a plant patent. Design patents protect the aesthetic of an invention, and the utility patent is something that's useful, that's functional. So patents protect inventions. And patents have to, in order to be eligible for patent protection, that invention has to be novel or new, which means you have to come up with something new. You can't just take what someone else did and, file a patent for that. Although you can, I guess I want to use the word piggyback off of something if you've made it new, if you've transform in a way that it's original. So patents have to be new, non-obvious. That means it has to be unique. It has to be something that you've thought of. It can't be something that's obvious and useful. And most, as concerns certain patents, they last 20 years from the date of application. Again, there are different types of patents: design, utility, and plant. So there are varying terms, but mostly 20 years from the date of the application. And the interesting thing with patents is you don't have to actually create the invention. But if you hold a patent for that invention, you can exclude others from creating that invention. So as where trademarks and copyrights, you acquire rights through use, at least with trademarks. For copyright, you have to express it in a tangible medium or form. For the patent, you don't have to use it. So some people may file patents, never bring that product to creation. However, they can exclude other people from doing so. And trade secrets. Trade secret protects proprietary business or company information that is commercially valuable or provides a competitive advantage, and it is not generally known. So that just means that your company created a system or something unique that generates money or puts you at an advantage as concerns your competitors, and it's not something that's generally known. Oftentimes when people use an example of a trade secret, they use Kentucky Fried Chicken or KFC's Colonel Sanders recipe. That is a secret. It's not generally known. It is commercially valuable, i.e. it makes KFC money, and it also provides competitive advantage for KFC. Now, one thing that you have to do in order to have a trade secret is you have to take reasonable measures to keep it secret. If everyone and their mother at your business and or company knows the recipe to your food, that is not a trade secret. It has to be kept. It has to be protected. It has to most companies put measures in place where not every employee has access to that information. It may be locked in a safe. Only individuals with, the highest classification or highest clearances in the company are able to access that information. That is taking reasonable measures to keep it secret. And as trademarks have the potential to last forever, trade secrets also have the potential to last forever. And there's no requirement that you register a trade secret. You just have to take reasonable measures to keep it secret, and it has to fit the commercially valuable and not generally known criteria. So that's our brief overview of IP. And if you counted, I hit 4 designations or 4 categories or 4 different types. Let me go back. Patents, copyrights, trademarks, and trade secret. Within trademarks, there's also protection for trade dress, which is the design or configuration of a store, if it's unique, if it's creative, and if it's just simply aesthetic and has no functional purpose, you can have trade dress protection. And Apple has trade dress protection for the design of their stores. Target just came out with a cool new concept design as well, and I would not be surprised if they have trade dress for that as well. And we can dig into that another time, probably talk about that on the podcast that the firm hosts. So we talked a lot about the different types of IP. Now I want to get into a hypothetical situation to show you the different ways you can protect your intellectual property or IP when you're launching your brand or building your brand, or even if you've already built your brand, you're growing your brand. These are practical steps and ways you can identify the types of intellectual property you hold and how you can go about protecting that intellectual property. So we're going to discuss Sally Entrepreneur today. Sally Entrepreneur is a boss woman who just graduated from Boston University with a degree in fashion design. And using her fashion design skills, Sally Entrepreneur has designed a unique, one-of-a-kind evening gown with not 1 but 2 trains. The evening gown has no functional aspect. It's just purely aesthetic, something that's unique, something that sets her gown apart from others because she has created a way where the gown has 2 trains, and that hasn't been done before apparently. So Sally, using her fashion skills, taking the knowledge she acquired from Boston University, is planning to open her own clothing boutique, Sophisticated Styles, in April 2023. Not only is Sally planning to open her own clothing boutique, she is also planning to launch an online store at www.sophisticatedstyles.com, where she will also sell her clothing items. So she's going to grab a domain name and she's going to sell her clothing line items online, as well as having a physical retail store location. Through her pre-launch marketing efforts, Sally has created a customer list. She's honed in on her target audience. She brainstormed ways to reach her target audience, and using those creative systems that she designed to do so, she has obtained a unique and created a unique customer list that she will use in obtaining new clients as she grows and builds her brand. And in order to further market her brand and bring awareness to her brand, Sally is planning to work with a local producer and creative director to create a commercial to promote her boutique before the grand opening. So these are a few things in our hypothetical that Sally is planning to do. She hasn't launched yet, but we're going to go through each of the things that Sally plans to do and see whether or not she can begin to protect her brand before she even launches her brand, and how she can protect her brand to grow her brand. So let's go ahead, Sally, and let you do what you do. How can Sally protect her brand? Well, we'll get into that in a second. If you have some ideas, drop them in the chat. How do you think Sally can protect her brand? Well, first, Sally can apply for a design patent. Sally can apply for a design patent. Because Sally has created a unique, one-of-a-kind gown, she can protect that aesthetic because she created it. She's not just doing plain t-shirts, things that have been done, but she has designed a unique evening gown with not one but two trains. That's something that's different. That's something that's new, unique. It's novel. And so it's because it's simply for aesthetic purposes, Sally can apply for a design patent. Now, if Sally had two trains and that train had a utilitarian function, it had some sort of usefulness, she could also apply for a utility patent. But in this case, because it's simply aesthetic, she can apply for a design patent. And you know what that design patent would do for Sally? It would prevent others from copying her design because she's done something that's brand new. She's not doing the same old, same old. She came up with a creative design for her gown, and to protect that design and allow her to maximize or her ability to monetize that creative idea, Sally can apply for a patent design. Patents do take a little bit of time and they can be a little bit pricey, but if this is truly a unique cutting edge design, Sally can go ahead and file a patent for that design even before she brings it to the market to protect it. Because we know even in the era of fast fashion, as soon as certain fast fashion brands see that design up, they're going to go ahead and get to work and make a lesser quality version, in 2 to 4 business days. So Sally can apply for a design patent. Some of you may not know this, to protect the aesthetic, that design of her gown. Excuse me. Excuse me. Excuse me. Sally can also apply to trademark her brand name. Oh my God. All right, there we go. Clear my throat. My bad, y'all. Oh, Lord. Sally can apply to trademark her brand name. So Sally is planning to open her own clothing boutique, Sophisticated Styles. And not only is Sophisticated Styles the name of the boutique, but it's the name of the brand. So within her gowns and her clothing, Sally will have the tag, Sophisticated, on the tag for the clothing. She will have Sophisticated Styles on that tag. And that serves as a source indicator for her clients. When they pick up that gown and they see the tag that says Sophisticated Styles, they know it's coming from Miss Sally from Boston University, who has her degree in fashion design. And so Sally can use that name on the store. If Sally launched an LLC, which Sally should, you should definitely open an LLC when or some type of business entity when launching your brand, to separate the brand from you as a person and create a legal business entity. And so even if Sally named her brand, her LLC, Sophisticated Styles LLC, the fact that Sally is also using Sophisticated Styles as a source indicator for her clothing will allow her to trademark that brand. And so Sally, maybe if she just sold clothing in store, as we said, for trademark rights, you have to participate in interstate commerce, which means you have to be selling your goods or services across state lines. Maybe if Sally just had her store in small town USA, she would not be eligible for federal trademark registration. But Sally is also planning to launch an online store. So in that online store, Sally's expecting to be able to sell to individuals in states outside of the state where her store is located. And so in trademarking Sophisticated Styles, Sally will also protect her right to obtain that domain name, sophisticatedstyles.com, where she will also be selling her clothing items. And not only could Sally trademark that brand name for clothing or for gowns, she could also trademark that brand name for retail services in the form of online retail services in the form of a store providing, access to the clothing. So those are several ways where Sally can use trademark protection to protect her brand, prevent somebody else from infringing on her rights. And also, if some cyber squatter decides to take up sophisticatedstyles.com, if Sally files for federal trademark registration and is successful, she can go through the ICANN process of addressing that cyber squatter, and that trademark registration will enable her to do so. And that's a more streamlined process that will enable her to combat that cyber squatter, because if she successfully files for federal trademark registration, she will have the exclusive right to use that name at that domain name for her goods and services. So Sally can apply to trademark her brand name, which will enable her to continue to sell her goods without fear of someone stealing her domain name. And if they do, she can fight back. And also for her customers to recognize that these are Sally's particular styles and serve as a source indicator for her goods and service, because the online store is a service that she's offering to the public so that they can purchase her goods or products. Sally can also protect her trade secret. Y'all probably didn't think that Sally had a trade secret. Sally does, in fact, have a trade secret. Sally has a trade secret in the form of her customer list. You see the papers that Sally has there on the slide. You see the glass of water that she has that I should have that I should have a little bit of. Sally can protect her trade secret. Through her pre-launch marketing efforts, Sally used a proprietary system to obtain a customer list, and that customer list is proprietary. That customer list puts her at a competitive advantage because she has access to a specific group of persons in the form of her list whom she can market to, whom she can put herself out there to sell her product. So guess what? Sally has a customer list. She has a trade secret in the form of her customer list. So Sally, in order to protect her trade secret rights, must take reasonable measures to protect that customer list. Not everyone in the company can have access to that customer list. Maybe only a few key persons in the company or her business can have access to that customer list. Sally should keep that customer list in a safe place. If that customer list is in digital form, Sally can put in place two-factor authentication. Thank you. Two-factor authentication to protect that list. She can put it in a Dropbox folder that has a particular PIN or key or password that only she and a few select others can access. She cannot be publicizing her customer list or, placing it in a public place. She has to keep it secret, take reasonable measures to keep it secret so that she can protect her trade secret rights. And if someone does some sneaky stuff and steals her customer list, then Sally will have rights to go after that person. And in those cases, it can range from the monetary damages that you may receive, or the monetary recuperation that you can see from damages can range from a few $1,000s to billions, depending on the type of trade secret, the size of your company, etc., etc. So Sally can also protect her trade secret and keep that customer list. Take reasonable steps to keep that customer list secret. If you have a business, you know how important a customer list is. So we can understand why she would want to protect that. And Sally can also register her copyright. So Sally, when she creates this commercial, will have a copyright, and she can register that commercial with the Library of Congress. She can register that with the Library of Congress. And so that commercial will be copywritten. And if anyone tries to steal that commercial idea and execute it in the manner that Sally has executed it in, then that person could be liable for damages for infringing on Sally's copyright. Now here, this case or scenario has a few interesting pieces. She plans to work with a local producer and creative director to create a commercial to promote her boutique before the grand opening. Now, what's interesting is that Sally maybe has the idea, or she's hiring individuals to help her execute the idea. And what Sally may also want to consider is creating a work for hire agreement with the local producer and creative director. What's a work for hire agreement? Well, maybe one day the creative director or local producer will say, hey, actually, that's my intellectual property or IP because I gave creative direction, or I added my take to it, or I gave this bit of information and I helped to bring this idea to life. Well, Sally can circumvent that from someone later saying, hey, we actually are asserting a right in this commercial by creating a work for hire agreement, which basically says that the individuals who are working for her understand and agree that the finished product and the finished work will be Sally's and not theirs. And so that way Sally can protect her commercial and prevent others from later on down the road saying, hey, I actually have that right to the work. So Sally can register her commercial with the Library of Congress to protect her copyright, and she can also draft and have the local producer and creative director sign work for hire agreements acknowledging that the finished work and product belongs to Sally. Whenever you're working with graphic designers and maybe photographers in your business, it's extremely helpful to get a work for hire agreement in place and have them sign that before you work with them. Because especially in the case of photographers, they may have an argument that the final photograph, is their creative work. And you do not, if you're paying someone to produce something for you, you want to be able to use that work and exploit that work, right? And use it in many different ways. So it is very wise when working with photographers, graphic designers, and people creating things for your brand or business to get a work for hire agreement in place and make sure that you're, again, protecting your rights so you can build and scale your brand. You don't want someone to produce a work for you and you try to use that in your branding and marketing efforts, and then they come back and assert a right, and then you have to, you're not able to use that work or that creative effort. So that's something definitely you want to consider in building and growing your brand. All right, so we've discussed the ways that Sally can protect her brand as she builds her brand. Her brand hasn't launched yet, but Sally can apply for a design patent to protect the aesthetic design of her product. Sally can also trademark her brand name so that she can protect the name. She can protect her right to use the domain name, and she can protect her products as well, because when she's using that sophisticated styles, individuals will know, hey, this is Sally's work, and Sally's work is quality work, so I can trust this. I can trust that this dress that I'm buying that has a sophisticated sophisticated styles tag on it is quality work. Sally can also protect her trade secret, take reasonable measures to keep that customer list that gives her a competitive advantage secret, so that she can maximize and monetize that list that she put together, that she took the time to obtain. She put in the effort in obtaining that list. She took in the effort in reaching out to those customers. She spent money doing so, and now she can protect it so she can make money. And as you guys know too, you can exploit your customer list rights. If you have a customer list, you can protect it by trade secret. But if you want to, and you can also gain opportunities, because if you have a large following and you have a large customer list, brands may want to reach out to you because you have a wide audience. And so that's another way that Sally can use her trade secret and maximize her trade secret rights to her benefit. And finally, Sally can register a copyright for her commercial. She can protect her idea. She can protect people from, next week trying to basically making the same commercial that she worked hard to make. And she can also use work for hire agreements to protect her own rights by having the producer and the creative director who she worked with acknowledge that she holds the right to that commercial. So Sally is now on her way to a protected brand and a successful business launch. And so that's a few ways Sally can protect her brand. And so we talked about how Sally could protect her brand, but I want you to think of Sally. And when you think of Sally, to think of yourself. Think of the different IPs that you have in your business. Think of the different creative ideas that you already have at play in your business and how you can protect them. Maybe you already have a commercial. Maybe you have a photographer that you work with frequently for your brand for marketing purposes, and you may want to begin to implement work for hire agreements with that photographer, because everyone's friends, but if it's not in writing, it didn't happen, right? So everyone's friends until everyone's not friends. So you want to make sure, even if you have a great relationship with someone, it's nothing personal, it's just business. Nothing personal, it's just business. And if it's not in writing, it did not happen. So you want to get that in writing. You want to be wise. You want to protect your brand. Brand protection is everything. And we protect our brand because we want to build our business on, or our brands on, successful or solid foundation. We want to build it on a solid foundation. You want to build on a solid footing, so you can just grow. If you think about the house that was built on sinking sand, when the storm came, that baby sank because the foundation was not solid. But the house that was built on the rock, even when the storm came, even when the storm rain spot fell, it still withstood the storm because it was built on a solid foundation. And so that's another important aspect of brand protection, building your brand on a solid foundation so that it can withstand the test of time, so that you can scale and grow your business, and so you can maximize your opportunity to monetize your creative ideas. And so if there aren't any questions, let me just go ahead and take a look in the chat. There's no questions. If you have any questions, now's the time to drop it in the chat. But I do want to thank you for your participation today. I want to thank you for your participation in this webinar series. If you ever have a question, please, and I guess I can add that now, feel free to reach out at info@kjllawfirm.com, info@kjllawfirm.com, and just indicate you attended the webinar, and we will attempt to answer questions. Now, as you know, all the information provided here today is not legal advice and should not be taken as legal advice. It is for informational purposes only. If you do need legal advice, please consult an attorney. So if you have any questions, we will try to answer general questions, but we cannot provide legal advice without signing a engagement agreement. So if you also want to schedule consult, you can go to www.kjllawfirm.com to book a call, or follow us on socials at KJL Law Firm and click the link in the bio to schedule a call so that you can discuss your particular needs. But I thank you again for attending. This is All Women's History Month. March is not over yet. We're about halfway through. I can't believe it. My God. I can't believe we're halfway through, but it's not over. It's not over. So we have 2 more webinars for you. And the next webinar is called Building a Brand. So we're going to get more into the mechanics of building a brand, what you should be doing to build your brand, even kind of going over a sort of things you should be checking, how you should be creating a checklist to make sure that you're hitting all your corners, you're hitting all your spots and building a brand. And then the following week, the final Thursday in March, we will be discussing brand protection in nonprofits, trademarks and nonprofits. Listen, nonprofits need brand protection too. Nonprofits need brand protection too. So we'll be covering that in the final Thursday of March. It's Women's History Month all month long. We're celebrating women. We're supporting women. We're educating women. We're empowering women. We're so glad that you decided to be a part, and we cannot wait to see you at the next seminar. Have an excellent, 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 excellent evening. And we'll see you next time. Bye.